Okay, so in this class we're going to look at copyright exemptions. Because of a technical error in the lecture, I'm giving this class now from my office, so obviously you can't ask any questions. But if you have any questions, maybe you can email me or we can talk about them in the next class. So it's important that we have specified exemptions to copyright rules, because for many kinds of copyright infringement, it's a criminal act. And so you can't have people having criminal convictions just because they crossed the line that wasn't very clear about what's possible and what's not. Also, there are kinds of things we do with copyrighted material that most people would consider perfectly reasonable. Technology has developed to the extent that copying things is not only easy but commonplace and part of everyday life. So copyright legislation in most jurisdictions, and in Ireland also, sets out very specific exemptions where copying is allowed to take place in such a way that a criminal act is not being committed. If criminality wasn't at issue, the rules might be a bit fluffier, a bit vaguer. But because it's a criminal act, it must be very, very specific about what is allowed and what is not. So copyright restrictions are not absolute. Just because you're the author of a work doesn't mean you have absolute and total control about every single act that may occur with it. Remember, if we go back to the instrumentalist view of copyright, copyright is a property right given by the state in exchange for something. And what we're giving the copyright to authors to encourage them to produce more works and have more works in circulation. So lawmakers have carved out exemptions to copyright rules, and the Berne Convention allows for that. You'll recall the Berne Convention sets out minimum standards that signatory countries must sign up to. And so if countries were to allow exemptions, the Berne Convention would have to have that specified. So Article 9.2 of the Berne Convention, which wasn't in the original convention, it came quite late, in the 1960s I think, there's this test or this exemption which we sometimes call the three-step test. So often in literature you hear people talking about the three-step test. And so legislators in countries of the Union that have signed up to the Berne Convention can, in certain special cases, it's part 1, provide that such reproduction does not conflict with the normal exploitation of the work, it's part 2, and does not unnecessarily prejudice the legitimate interests of the author. So in certain circumstances that aren't going to basically screw the author of the work, the legislature can set out exemptions to copyright rules. So if you think about some of the copying we do in our day-to-day lives, what kinds of things are perfectly normal that we don't expect people to go to jail for? Well, the first one, of course, is taping shows, not that we use tape anymore, but taping shows on television so we can watch them later. So if you have access to a broadcast channel or a cable channel or a satellite channel, we all agree that it's perfectly reasonable for you to record a show so that you can watch it at some later time. That's the technical term for that, is time shifting. But in doing so, you are making a copy of someone's work. So if we're going to make sure that half the population of Ireland doesn't go to jail, then we need to have an exemption for that. So section 101 of the Copyright and Related Acts in Ireland provides specifically for this. So the making for private and domestic use of a fixation of a broadcast or cable program solely for the purposes of enabling it to be viewed or listened to at another time or place shall not infringe the copyright. Okay? So if you record something off the television or off the radio in order to watch it at a different time or a different place, then you are not breaking the law. There's an extra part here, of course. Notwithstanding that, if you go around selling those copies or renting them, well then, you're having us on, really. Okay, so obviously you can't go selling those copies, but you can actually give them to a family member or a friend, provided it's for private or domestic purposes. So you can see here that the legislators have gone to great lengths to carve out this exemption here so that people can do what we all think is perfectly reasonable. I mean, back when video recorders first came out, this was a big issue, and copyright holders were quite cross that people had access to this technology, and there were all sorts of schemes and all sorts of debates and all sorts of cases. But now as a society we've settled on this solution that this is quite acceptable. It is interesting that there's even we have the exception, and then we have the exception to the exception if you're renting the stuff or loaning it. But then we have the exception to the exception to the exception. If you can loan something to a family member or a friend. So again here, the law is capturing the kinds of behaviors that people engage in that we all think are quite reasonable, really. I mean, if I tape a show and, loan it to my sister or something, that's perfectly fine. So there are a whole other bunch of exemptions as well, things we might not think of. I think taping shows is something that would all come to mind to any of us. The next one then, of course, is things to do with education. If we had a very strict interpretation of copyright law, then we could just post a policeman at every photocopying machine in the country and just fill up our jails of people breaking the law. So there are scenarios, we set out exemptions in certain situations. Education is one. So it's a whole bunch of exemptions for education. And again, they're quite detailed. They're quite specific so that the kinds of things that we all think are reasonable for people to do in an educational context are allowed. But then those are also further constrained so that people don't use the education exemption to get away with things we shouldn't allow. Libraries and archives are something we often don't think of, but libraries, of course, keep books and movies and music and stuff, and they would be loaning those things out to people. So provision has to be made for that. But also many libraries are engaged in archival work where their job is to protect works for future generations. And you could imagine a scenario where a book or a drawing or some work is in very poor condition, and a library would need to make a copy of it to ensure that it's preserved for posterity and for future generations. Google, for example, took this to extremes and began copying entire collections of libraries. And that caused some controversy because some of the works were still in copyright. I mean, we all know there's no problem with copying works that are out of copyright, that have, the author is long dead. But copying works within copyright is a problem. And so there are scenarios where that's acceptable for archival purposes. Public administration isn't something we would often consider, but the business of government often requires works to be copied. And if you take, say, a planning application and there's a drawing of a building, well, someone owns the copyright to that drawing. it's perfectly reasonable for the planning office to produce copies of that, or to put copies of that online, to even produce copies and distribute them at meetings, whatever. So in the business of public administration, copying has to take place. Also, court cases. There may be copyrighted material that needs to be reproduced in order to allow the courts to do their jobs. Also, it may be necessary to publish the judgments of the courts, and that might include some copyright material as well. So things like that. So taping shows at home is something we can all think of. Students and teachers copying extracts of books and stuff, that's something we're all kind of familiar with. We probably didn't think about libraries, archives, and public administration. So in Ireland, we have this concept of fair dealing. So this is the term used in Irish legislation. I think it's similar in the UK. We'll see in a little while in the US there's a different concept. But the idea here is that, yes, we do have copyright. Copyright owners have exclusive rights to decide who can do what with their works. But there are these things that we consider to be acceptable. And again, all of these would meet the 3-step test that's set out in the Berne Convention. If they didn't, they wouldn't be allowed. So, fair dealing with a literary, dramatic, or musical or artistic work, right? For the purposes of research or private study, shall not infringe any copyright work. So if you are a student, essentially, if you are doing research, then there are things you can do that would, under other circumstances, be a copyright infringement. But you can do them because you're engaged in research or private study. If we look here in part 4 of that, this can all be done provided it does not unreasonably prejudice the interests of the owner of the copyright. So here we see the fingerprints of the Berne Convention over that part there. So if you're claiming that you are engaged in fair dealing, then part of the test for that is what you're doing, would that prejudice the interests of the owner of the work. So if you copy an entire book instead of buying it, well, that's prejudicing the interests of the owner of the work. If you copyright a page, it's hard to argue that that's a big deal. But all this can only happen if you're engaged in research or in private study. A person who's doing neither of those activities can't copy even a page without infringing. Now, in section 51, then, there is fair dealing with the work for the purposes of criticism or review. So if I want to review a book, I might include an extract, a few words from the, well, no more than a few words. I might include an entire paragraph from the book if I want to discuss the author's writing style or something. In that scenario, because it's for criticism, that's a perfectly reasonable thing for me to do. So if I'm writing a long essay on the works of J.K. Rowling, it's perfectly reasonable for me to use extracts from her works as part of that. Now, we could discuss then at what point have I crossed the line. You know, perhaps if my review of one of her books gave away all of the major plot points, so much so that someone might decide to dispense with the reading of the book altogether, or dispense with the purchasing of the book altogether because I had given away so many spoilers, then you could argue that I'm not engaged in fair dealing there. Okay. Similarly, if you are engaged in reporting of current events, then you would not be infringing the copyright on the work, except for a photograph. So obviously the photographs associated with reporting current events are actually quite valuable works. I mean, it's people's job to go take those photographs. If you were to argue that you could include those in a fair dealing exemption, well, those people would lose their jobs. But otherwise, it's acceptable to use people's works. So you could consider, for example, a politician making a speech and someone taking down extracts of that and publishing them. If that's reporting of current events, then that's perfectly fine. You'll recall we looked at a case that involved that, but that's a whole other thing. Now, you must also then give acknowledgement. So there's fair dealing then in education, where there's a whole bunch of very detailed exemptions. And the reason for that, of course, is that up and down the country, teachers and lecturers and professors are standing at photocopying machines, taking extracts of works to give to their students. So if an artistic work is copied in the course of instruction or preparation for instruction, then that's acceptable. But there are conditions. So the copying must be done by or on behalf of the person giving or receiving the instruction. So a teacher can do the copying, or a student can do the copying, but some random stranger can't go copying works and claiming that they are included in this exemption. So again, you see we have the copyright rules, we have the exceptions to those, and now we have the exceptions to the exceptions, so that people can't use the exceptions to go crazy and have excuses to do whatever they want. Okay? The copy must be accompanied by sufficient acknowledgement. Okay? Things like that. Interestingly, which surprised me, so you can, if you're a teacher or if you're a student, you can copy a sound recording or a film, or indeed a database. That can be done, provided it results in only a single copy being made. So this is quite clever. So if you are, for example, taking a film course and you need to do a very close analysis or very close reading of a particular film, conceivably you could make a single copy of the film for your study without breaking the law. Although we could argue that doing so would harm the rights of the owner, and so it might unreasonably prejudice the interests of the owner. So perhaps a whole film might be a stretch, but there's certainly some wiggle room there. But of course, if you are a student and you make 200 copies of a movie, you don't get to use the fair dealing exemption. Another one, and it actually caused some controversy in Ireland some years back, was that if you are setting an examination paper, you can actually include copyrighted works in the questions. So, for example, if you were giving people a test and you were asking them to comment on a particular poem, you can reproduce the entire poem in the examination paper without that being an infringement of the copyright. Now, in the US, there is a much broader equivalent of fair dealing, and that's called fair use. and this allows every author or publisher to make limited use of another person's copyrighted work for purposes such as criticism, comment, reporting, teaching, scholarship, and research. Now, once again, we do have pretty much the same circumstances. So criticism, commentary, reporting of current events, we saw that in the Irish legislation, teaching and scholarship and research, we saw those too. So it's the same idea, and most jurisdictions have some sort of fair dealing or fair use exemption from copyright law. The precise definition of fair use isn't set out in the US, but the courts consider the following. So the purpose and character of the use. So what are you doing? The nature of the copyrighted work. So, is it a song? Is it a book? Is it a poem? The amount and substantialness of the portion used in relation to the copyrighted work as a whole. And substantialness is important because it's not like there's some threshold where, say, if you use 30% of something, that's okay, but if you use 31% of something, that's not. I mean, if a song was 3 minutes long, it's not that you could use, if you use less than 1 minute, that's okay. I mean, for a song, there might be, 10 seconds of a song that are hugely substantial, that capture sort of the essence of the song, that, the whole mojo of the song is in those 10 seconds. So it's not just amount, it's not a numerical measure. It's more subtle than that. So it's how much have you taken in a more general sense. And then importantly, and this goes back to Berne again, the effect of the use upon the potential market for or value of the copyrighted work. So if the person claiming fair use has produced something, or the copying that they are doing is going to affect the potential market for the original work, well then that's probably not fair use. Also, if the work is treated in some way that its value might be affected by the use, that can also have an impact on the decision. So often you will hear people in the US, as part of a YouTube video or something, very, very explicitly say, this is a work of criticism, or I'm making a commentary on this work. And so they are trying to make it very explicit that they are availing of the fair use exemption. Now, come back then to Ireland. There are some other exemptions as well, quite technical ones that you probably wouldn't have considered. They're not something that would happen in day-to-day life, but they are to do specifically with software. So there are things that you are allowed to do with software under certain circumstances. So converting a program expressed in a low-level computer language into a version expressed in a higher level language. Okay, so that's not allowed. I think I just said it was allowed. It's not allowed. Okay, so decompiling a computer program isn't allowed. So yeah, when someone is, that's a very technical thing, but when someone is decompiling a program, as a general rule, what they're trying to do is create another version of the program that's the same but not the same. It goes a bit to the idea-expression dichotomy. It kind of sits on that boundary there, so it's a tricky one. Okay, but anyway, that's not fair dealing. So decompiling a program is not allowed. Okay. However, making a backup of a computer program, that is. So if you are entitled to have a single copy of a computer program on your computer, you may make a copy of that for backup purposes, and that is that's acceptable. That's not a copyright infringement. Of course, that only applies if it's lawful for you to have it there in the first place. Okay. Now, computer program interoperability then is a fairly complex thing, but if you can imagine you have one computer system that wants to communicate with another computer system, and so your job is to write the code for the second one, and you need to interact with this older one. So let's say, for example, you have a banking system, and it was written 20 years ago. You want to write some new code to work with that. Well, then there may be some things that you have to do in order to achieve that task that might, under other circumstances, be considered infringement of copyright. So there's an exemption here for certain things. So you can make a permanent or temporary copy of the whole or part of the computer program by any means and in any form, or you can make a translation, adaptation, arrangement, or any other alteration of the computer program, and to copy it, to achieve the interoperability of an independently created program. So I'm writing a new program, but it needs to talk to this other program. Well, then I can do all sorts of stuff to the other program in order to make that happen. This brings us then to a rather interesting question about the nature of culture in the 21st century, or even late 20th century. So this here is a very important collage by Richard Hamilton. It was created in 1956, and its title is "Just What Is It That Makes Today's Homes So Different, So Appealing?" So way back, you would have had painters and poets and musicians and artists going out into the environment, out into the hills, into the countryside, and a lot of their work was responding to the environment around them. But in the second half of the 20th century, people were swimming in media, and the environment people lived in contained all sorts of advertising and cultural products, and many artists began to respond to that environment that they found themselves in. And so this collage was one of those works, and it's a very important work. And it raises the interesting question, how much or to what extent can a creator use the creations of others to make a whole new creation? So while we accept that this work has a copyright in it, of course, but the question is, was in the creation of this work, did the author, did Richard Hamilton, infringe the copyright of the original photographers? Most of the bits here were taken from American magazines, actually, as it happens, even though he was in the UK himself. And we would accept that this is an art form, we would accept that this is an important work. The question is, was there copyright infringement in its creation? And I think most people would argue that, well, no, it's a whole new work, and the substantialness or the amount that was taken from the original works was small. But it does pose an interesting question, because it has parallels then in popular music and in rap music. And when one musician samples another musician, to what extent is that acceptable? To what extent can you use tiny portions of someone else's work to create a new work? Is that fair use? Is it copyright infringement? Is it infringing on someone's moral rights? All of these questions come into play. For the most part, in modern times, when one artist samples another, the lawyers get to work and come to some sort of a licensing arrangement. But the question remains, if the lawyers hadn't become involved, would sampling be an acceptable practice anyway? And certainly I think in this work, I doubt that any of the individual components was licensed by Richard Hamilton. But it is an entirely new work, and most people would accept that what he did was legitimate and not an infringement of anyone's copyright. But when we translate the same question into music, we kind of come to slightly different conclusions. So it is an interesting one. We do live in a culture now where remixing things is very important. Someone posts a video to YouTube and someone downloads it, remixes it, edits it, mixes it with other things and uploads it back. We consider that to be a legitimate practice. We consider it to be a valuable practice. It's something we want, and it's something we encourage, it's something we all enjoy. It's part of our culture. But copyright law hasn't really caught up with the kinds of things we would like to do there. So perhaps there's some scope for the law to expand the likes of fair dealing and fair use even further. Okay, so we'll leave it there. So the important points here are that because copyright infringement is criminal, and we don't want to be criminalizing activities that we consider acceptable. So we have set out very specific exemptions to copyright for things like taping shows on TV, students photocopying the odd thing here and there. And that works quite well, but then also to make sure that people don't use those exemptions to get around copyright, we've even seen that those exemptions have exemptions. So once again, though, it's important to realize that the law is the servant of, the culture, the society, and it has been crafted to meet our needs.